about Darbro, and then we're going to have some questions to discuss about why did these cases come out differently. So in this case, over here, Thomas and Robert Theberge sold real estate properties to the Warden Group. So here's the properties. They sold it for $900 in cash. And the Warden Group didn't have enough to pay them the whole thing, so the Warden Group wrote them a note, a promissory note. It basically said, this is a debt, we're going to pay you $180 back. It didn't seem like there was any interest on the note, but it was an IOU, just a person-to-person IOU. Now, after that transaction was consummated, and now the Warden Group owns the property, the barges are still out $180. They're still waiting for $180 to come through. So they're not fully paid. That's why they're still part of the picture here. And then the Warden Group, I guess they didn't really like these houses, so they decided to sell it to somebody else. Now, first, they try to sell it to A&M, which was Albert and Mitchell Small. So the Smalls own a company called Darbro, and there, I guess, was some discussion the Smalls would purchase this personally, but they decided that wasn't so smart. It would be smarter to do a real estate deal through a corporate entity. Because why? They wanted a liability shield. They wanted to protect themselves from the debts of their company. And so they formed a corporation. And this corporation was called Horton Street Associates. So Horton and Darbro had the same ownership, the Smalls. And that's how Darbro gets pulled into this as well. So this transaction is $840 in cash, which was paid from a mortgage. So Horton Street owes the bank some money, but we don't care about that. Over on this side, we've got our $840, right? So we don't care. The bank might get stuck or not. Now, they also assumed the note, so that note is still outstanding. So that the barges are now owed $180 by HSA for this note, and they wrote another note for $20,000. The lenders to Horton Street received guarantees. So this mortgage was guaranteed by the Smalls, but this note was not. Right? And as I mentioned, this mortgage is irrelevant. It's in parentheses, irrelevant for our purposes here. It was like cash to our plaintiffs. But the note, this was not as good as cash. The note is, it's not cash. It's a promise, it's an IOU. So, after the purchase, the real estate market started to deteriorate. It's 1996. And began to lose money. And the Smalls and Darbro, which is, again, they get drawn into this, they loan money. They loan $225,000 to Horton Street. Now, it's not a gift, it's a loan. And it's obviously not an arm's length transaction, but it does show some amount of connection between these entities, which are obviously connected. I mean, they share a common ownership. But that wasn't enough. The $225,000 loan was not enough to keep the company afloat. And they tried to renegotiate, but in any event, they were unable to pay and service this debt. And so the barges and the Warden Group brought an action to recover a balance on this note. Now, HSA doesn't have the money to pay the note, but I guess the Smalls and Darbro did. So the question is, do the Smalls and Darbro have to pay the $180,000 note? Well, the only reason they'd have to do so is if we pierce. Are we going to pierce the corporate veil on Horton Street up to the Smalls, or across the corporate groups to Darbro? Right, so remember, that's alter ego and enterprise liability. We learned about that last time when we talked about torts. This is like the case of the taxi company that had, or the 9 taxi companies that had one owner, Carlton. Here, the Smalls own several companies. And so we have an enterprise liability theory as well as an alter ego theory. We're going to try to pierce sideways and up. So initially, a default judgment against Horton Street was issued, and a second action was then, so the Horton Street basically didn't show up in court. So that's step one. So they say, pay us the note, and they say, well, nothing. They didn't show up, and so they lose. They probably had no money. It wasn't even worth fighting. They obviously owe the money. They're going to lose anyway, so they take the default judgment. A second action was then initiated against Darbro and the Smalls personally for the remaining balance unpaid. And the theory was that Horton Street was the alter ego of Darbro and the Smalls, although enterprise liability would have been a better theory for Darbro. Now, the trial court concluded that the Darbro and the Smalls were liable to the Wharton Group and the Theberges for the outstanding balance. In other words, the trial court said, yeah, go ahead and pierce. But did that verdict hold? What happened at appeal? At appeal, this was reversed. Why did the appellate court reverse and say the trial court erred in piercing? Because the evidence was insufficient to justify piercing here. Justice Glassman found that a corporation's legal entity should be discarded only when necessary for the interest of justice and with caution, applying a very stringent standard, reminding us that piercing is exceptional. And a party is generally presumed to be insulated from liability when another party enters into a contractual relationship with them. We need something more. We need what we might call plus factors. Were those factors here? Right? Well, it was a closely held or even a two-person held, almost sole shareholder, so kind of meet the sniff test of something that could go farther. Was there misrepresentation? There was no misrepresentation here. The court says that there was some sharp business tactics and shrewd dealing, but these are big boys and big girls. They know about corporate law. They understand that there's a limited liability shield. They originally were going to sell to the Smalls, but they agreed to sell to Horton Street Associates, and they know the difference. The trial court also determined that the Smalls did not, as a matter of fact, personally guarantee that loan, and that the Barges were sophisticated real estate professionals, so they can protect themselves. There was no evidence of commingling assets. There was no evidence of failing to follow corporate formalities. Now, undercapitalization. Let's talk about that for a second. Do you think that the company was undercapitalized? What evidence would say that the company was not undercapitalized? What does it mean to be undercapitalized? Well, yeah, Brett.
Well, be undercapitalized means they aren't holding money to cover their liabilities. I mean, they took in a $225,000 loan to try and cover their liabilities, but the company continued to tank. So therefore, I mean, you don't just keep pumping money into a failing business.
There's no obligation to keep pumping money into a failing business. Just look at the direction of this arrow. That's a big number going this way, into the company. Right, what was the issue here? Where was the money going here? The money was going out. Here the money is going in. How could you say that's they put $225,000 more dollars to keep the company afloat. There's no obligation to keep a failing business intact forever. If there were, what's limited liability? Right, it eviscerates the meaning of it. So why do these cases come out differently? Thoughts? What are some distinctions we can make between the case of C3 and the case of Darbro? Well, one is the direction of the money, right? And that's an important one. We don't have any evidence of undercapitalization. We also don't have any evidence of domination and control. They're not running this company. Essentially, this is an independent contractor. This company does nothing without Glazier. Its entire purpose is a vehicle for him to provide his consulting service. Consulting. You ever met a consultant? What do? They consult. Huh? It's vague, right? Whereas a real estate holding company is something a little bit more clear. So Glazier is actually running C3, and he's doing it in this convoluted way to avoid some roadblocks that were put up, whereas Horton Street Associates is exactly how you'd expect a real estate holding company to be structured. C3 was really a shell. In fact, Glazier Inc. was a shell. None of these had any significance or economic reality or any purpose outside of a convoluted structure in order to get a license to allow Glazier to run his business for his own profit. Here, a real estate holding company, what they're putting money into, they're loaning. Where this company is significant enough, it's getting a bank mortgage. A bank lent $840,000 to this company. So there's evidence that this is a real entity here. So what about the wrongdoing? Well, this is a closer issue. On the one hand, we don't know what these practices were. The court characterizes the practices in Darbro as sharp and shrewd, but not wrongful. On the other hand, we know that this guy was scheming. What is the difference between something that is sharp business practices and shrewdness versus acting wrongfully? It's a matter of judgment. These cases are actually closer than they may seem. Obviously, the trial court found that we could pierce here. So, upshot from this, all right, going back to our piercing factors. So when will we pierce? Well, first off, if it's a public company, we never pierce. We see that in the cases that we have piercing or something close to piercing, usually it's a single shareholder, sometimes it's two, occasionally it's three. Next, it seems to have some difference in what type of, we have to at least explain why torts and contracts are different. Professor Thompson found that courts pierce in 42% of contract cases and only 31% of tort cases. Professor O thought it was closer. What's the difference? Well, courts may be changing how they feel about protecting tort claimants and companies abusing the corporate veil. Having a sole shareholder, that's a big plus factor. Dominating and controlling. Every case that we see with piercing, there's some element of domination and control. It's part of the alter ego theory. Failure of formalities, well, we don't know that there was a failure of formalities here, but the other facts overcame it. He was using the corporate structure in order to get around Columbia University's rules. Inadequate capitalization seems to be an issue here in C3, where he was withdrawing money. 10,000 is not enough. Here, it's hard to say. The company, in hindsight, was inadequately capitalized, but why? Because it actually was a failing asset, not because they were withdrawing funds from it. There didn't seem to be any misrepresentation here. Here, Daniel Freeman looks like he was lied to, right? Treated wrongfully. And there were personal guarantees in this case, in the case of Darbro, but they applied to the mortgage, which was not pertinent in this case. There are no personal guarantees about repaying the note. So, factors. What is the most important factor? Probably misrepresentation. Basically, courts are saying, if you lie, if you use the corporation to lie, we're not going to give you limited liability. Abuse of the corporate form seems to be next, treating the corporation as it's really your own. We're not going to give you the benefit of the corporation if you're going to take advantage of it. We're only going to let you use corporations for their intended purpose.